Welcome everyone to the CITP weekly seminar. Our guest today is Woody Hartzog, who's professor of law and computer science at Northeastern University. We're very fortunate to have Woody with us today. He's an incredibly prolific scholar in law and technology, and he's contributed seminal legal work on data privacy and security. Woody's one of the rare legal scholars who goes out of his way to integrate technical sophistication into his work, and perhaps even more rare to hold a joint appointment in computer science. His articles have appeared in, among other venues, the Columbia Law Review and the California Law Review. If you're interested in the Federal Trade Commission's evolving approach to data protection, by the way, I cannot recommend his article in the Columbia Law Review highly enough. It's just a classic of the field at this point. I use it in my own teaching. Woody also authored Privacy's Blueprint, The Battle to Control the Design of New Technologies, a terrific book on the role of design in data protection. And he has a new book in the works on data security. In addition to being a very successful scholar, Woody has done terrific work in policy engagement, including testifying several times before Congress on privacy and data protection issues. I could say much more, but if you're interested, just Google him. So I'll leave it there. Welcome, Woody. I'm very excited to have you with us today.
Thank you so much, Jonathan. I really appreciate it. Thanks to you and Jean and Patrick and everyone at CITP for having me. This is something that I, of course, had hoped would be in person and hope that one day again we'll be able to see everyone in person, but I'm really glad to have the opportunity to speak to you now and today. And what I want to speak to you about today is actually part of a larger research project that I have engaged in with Neil Richards at Washington University. We, over the past almost 6 or 7 years, maybe even more, have been talking about the relationship between trust and privacy generally. And starting with an article in 2016 called The Importance of Taking Trust Seriously in Privacy Law, we put forth the theory of privacy and trust within relationships centering around 4 major values: honesty, discretion, protection, and loyalty. And the first 3, honesty, discretion, and protection, are related to existing data privacy principles that many people are familiar with. But the concept of loyalty is relatively new within privacy law, but of course very old within the law itself. And so a lot of what I want to talk about today is a research paper that we have written that's one of several research papers about the concept of loyalty and privacy law and the way that it relates to several other issues that we're working on. Some of the other stuff that's part of this, and you'll see this coming through in the presentation. Neil and I have also written about the pathologies that we see in the consent model of data privacy, the idea of notice and choice. We've also written a fair bit about how myopic the entire endeavor of data protection actually is. And we see that this myopia is limiting our imaginations with respect to data privacy in the United States. And one of the things that we've noticed is that as state laws now start to pass their own individual, basically versions of the CCPA, we're sort of getting into, we think, a little bit of an ossified framework for data privacy that we hope will be able to break out of. And this paper is our attempt to offer an alternative way to think about data privacy rules in the United States. And it's building off this concept of a duty of loyalty. And we think that this is a relatively timely issue because the duty of loyalty is actually starting to pop up in various different bills that are being proposed that have not necessarily been passed yet, like the CCPA, but the Data Care Act proposed by Senator Schatz, which is making its way through Congress right now. Senator Cantwell's bill that has been proposed, the privacy bill, has also a duty of loyalty in it. And it brings up this very big question, which is, well, what should loyalty actually mean? How does it apply? I mean, it's something that we hear a lot with respect to fiduciary obligations, but it's not entirely clear how it should apply. And so in this paper, and I'll go ahead and share my screen now. So in this paper that Neil and I wrote together, we put forth a theory of a duty of loyalty for privacy law. And before we get into the specifics of the theory that we propose, I first wanted to back up a little and talk about where we are with the state of things. So the first thing is, I probably don't have to tell any of you just this massive scale at which personal information is collected and sorted. But in order to properly couch this, I first wanted to note the fact that because of so much information that is being collected about us, it is able to be sorted. And companies are able to use that to sort people into various categories, which can result in various kinds of discrimination, where some people are privileged at the expense of other people. Predictions are being made about people that, based on our personal characteristics, we can assume that they will act in one particular way or another. The next thing that I want to set the table for is the fact that companies, of course, also control our mediated environments, controlling what we see and what we can click on. Companies are relatively sophisticated these days and know that people have limited resources to be able to make particular kinds of decisions, and that people react to certain contexts and situations in very predictable, if not optimal ways. This is an example of one of those ways in which companies tend to control, or at least try to channel, our particular decision-making behavior by highlighting the option that they would like for us to engage in. Yes, please take offer. If you'll notice, it's blue, it's brilliant, it's shiny. And then, of course, the negative option is not highlighted, it's transparently white. And so it's clear which decision this company would like for the user to engage in. And they are able to sort of channel that behavior through their control over the mediated environments. And finally, this confluence of the ability to have so much information about us and the ability to control our mediated environments gets met in a way that sets up entire frameworks for manipulation, the leveraging of data and our mediated experiences to get us to engage in particular kinds of activities that those that control that information, that control those experiences, would like us to engage in. Some of you may recognize that this is the user interface that was at issue in the FTC's complaints against Facebook for its role in facilitating the Cambridge Analytica scandal, whereby a third-party app used a system that was set up to exfiltrate large amounts of data under the auspices of consent and voluntary choices. And so all of this has created a framework that essentially means that there is a significant amount of self-dealing going on with digital technologies. These are decisions that are being made by companies to enrich themselves with little consequence for the needs and well-being of the people about whom are interacting with these companies and about whose data is being collected. And so often this self-dealing is actually adverse to the best interests of people that interact with these companies. And so in my talk today, I want to make 3 points, and these are the 3 points that Neil and I try to make in our paper as well. The first is that the law does very little to limit companies' self-dealing with people's data and their online experiences. We propose that lawmakers should enact a duty of loyalty in order to limit or mitigate that self-dealing. And we think that a duty of loyalty would actually help overall be an important foundational piece of the US response to data privacy issues, and that without it, self-dealing will remain a significant problem. Okay, so first let's start with the first point. The law of US data privacy does very little to limit self-dealing. When I give short versions of talks on data privacy, sometimes I I shortened the entire textbook of US data privacy. Here's one of them right now. And I say, you could read all of that, or you could know that there are essentially 3 rules for data privacy in the United States. Do not lie, do not harm, and follow the fair information practices. If you get those 3 down, then essentially you've cracked the nuts on how the United States approaches data privacy. The problem with these 3 rules is that none of these 3 rules adequately responds to the problem of self-dealing, and here's how. Let's start with the first rule. Do not lie. Do not lie. This ethic is embodied in Section 5 of the Federal Trade Commission's prohibition against unfair and deceptive trade practices. And it essentially says, as long as you are being honest about your intentions, then we have a role where consumers can interact with companies in a safe and sustainable way with their expectations being met. But of course, the problem with that, as many of you know, is that you can hide the technical truth in a place where no one is ever going to find it. And of course, everyone knows that I'm talking about the terms of use agreements and privacy policies that are ubiquitous on every single application and website on the internet. Now, the problem, of course, is that there's a trap here with the terms of use. On one hand, people demand simple terms of use agreements, right? And so the proposal is, well, one of the ways in which we can keep companies from self-dealing is forcing transparency. There's the idea is that the transparency mechanism will cause companies to pull back on any sorts of egregious behaviors, harmful self-dealing behaviors. But companies can actually get away with a whole lot of stuff by engaging in one of 2 potential strategies. So the user says, listen, all of this information, all of this legalese is too long, it's too confusing, please make it simple for me. Okay, the companies say. They abstract away the meaningful risk and say, we will collect all sorts of information and share it with trusted third parties, right? That is simple, it is short, but it doesn't tell us much. It doesn't tell us much about adequately disclosing risks, and companies can hide the extensive self-dealing that they're engaging in that sort of abstraction. Okay, you say, the other strategy is tell me everything. I want to know every single thing that you're up to. But of course, that also is so much that it overwhelms us and we result not being able to internalize almost any of it. And so companies are able to engage in this self-dealing simply because the notice and choice mechanisms are not only not working, but potentially theoretically impossible at scale. So the next harm, the next rule of privacy law that essentially facilitates self-dealing is the do not harm ethic. The do not harm rule is embodied in lots of different privacy rules, most notably perhaps the Federal Trade Commission's prohibition on unfair trade practices that tries to limit consumer harm. So of course, it also is inherent in the privacy torts and lots of other statutory regimes that require some sort of showing of a negative outcome for someone. Usually it can be financial harms, some kind of emotional injury if it's highly offensive, that it would be highly offensive to a reasonable person, or that someone suffered extreme emotional harm, or some other significant measurable cost to an individual. And the do not harm rule enables sorts of self-dealings because the requirement for what constitutes one single individualized harm in the world of privacy is really difficult, because it often doesn't cover the problem of the death by 1,000 cuts. And so what do I mean by that? So there are lots of small little ways in which companies can design their systems and leverage the data they have and their knowledge about the way in which humans work to very slowly cause us, at least at scale, to make decisions that expose us or cause small little annoyances in ways that don't ever quite register for that harm requirement. This is one of my favorite examples, where they make you click if you don't want those sorts of notifications. No, I prefer to bleed to death. Which of course seems funny now, but At scale, this sort of attempt to manipulate people into clicking the allow button, the exposure button, over time results in a significant harm that never quite violates the do not harm rule on an individualized basis. One of the things that it also doesn't accommodate are the sort of indirect kinds of designs that encourage people to expose themselves more often. They try to get streaks running, for example, on Snapchat that, expose yourself just a little more because you did it 10 days in a row, and don't you want to keep that streak going? That there are these sort of buttons that keep us online, that keep us engaged, that are meant to feed our addictive personalities, none of which would really violate the cognizable, concrete injury often contemplated in privacy law, but are pernicious nonetheless. And then the final rule of privacy law, which is embodied in the GDPR, it is embodied in the California's Consumer Privacy Act and all the essentially proposed data protection rules that are floating around at the state and federal level, is this idea that we should follow the fair information practices. And most people are fundamentally familiar with the fair information practices. They are things like giving people transparency rights, the rights to correction, the rights to notification. You have to protect information. They are meant to enable informational self-determination, the idea that we should be able to delete information about us, correct information about us. And one of the key advantages of the fair information practices is actually that it is the closest thing that we have to a common language of privacy in the world. Amazingly, as diverse of a concept and nebulous of a concept as privacy is, we have achieved this weird status where almost everyone in the world agrees that the fair information practices are good and should be embodied. They're almost non-controversial at this point. But the problem with the fair information practices is the way that they get manifested in technological systems is to give people control over personal information. And this is seen in a lot of different ways. And the reason that this doesn't stop self-dealing is that when control is granted at scale, when the wish to give people privacy and the way that you give people privacy is you give them control over personal information, when you actually do that, it turns into, at scale, a system that enables self-dealing, that actually facilitates companies getting to engage in the kinds of behaviors that are adverse to our best interests. Now, I know that seems counterintuitive. So what do I mean by that? Well, the way in which control is bestowed in mediated environments is through something like this, right? You turn it on, you allow geolocation, you turn it off, you don't allow geolocation. This seems relatively simple and good, right? Except, of course, it's never just one button. It is a series of buttons. So we say, okay, so now I'm going to I've got all this control. I'm gonna look at this. I'm gonna calibrate my compass. I'm gonna find my iPad. I don't know what location-based alerts are or iAds. That seems like maybe a thing I don't want. And then so you spend some time and you work out the settings. And you say, okay, finally, I have exercised control. My privacy has been respected and things are good. And you sit back and you take a deep breath and you say, oh my gosh, I've got to do this for everything, right? The problem with thinking about privacy as control over information and informational self-determination is that if we're given our wish for privacy, then we're given so much control that we choke on it. And when that is done, we become overwhelmed, we become fatalistic, and we allow all sorts of self-dealing to occur in ways that are subtle and undetectable because we've been sort of given this, I think probably a threadbare version of control while allowing all sorts of other kinds of data decisions and design decisions to go unnoticed. So what Neil and I have come to conclude is that there's another way, and it's not a way that is in opposition to the existing approach to US data privacy law, but in harmony with it, that it could be implemented in addition to it. And that is a relational approach to data privacy. The idea that there are certain sorts of rules that we might want to establish around the data itself. And this is what the GDPR does. This is what the CCPA does. It asks questions about who's collecting the data, what are they going to do with the data, the protections follow the data, and that's all well and good. And they sometimes pair them with structural changes, which is also well and good. But there's another kind of dynamic that is often glossed over in these data protection regimes, and that's the privacy that people have within information relationships. The idea that we disclose information within a context of a relationship, particularly one with a great power differential. And this is really where we think that trust comes into play, because companies invite trust, which we define as the voluntary exposure to vulnerability, right? The willingness to make yourself vulnerable to another party. And companies invite it. They say, share your information with us. Come, make series of choices within our mediated environments. We will take care of you. We will use your personal information. Many are probably familiar with the idea that your personal information is important to us. We've heard this phrase over and over. And so Neil and I have argued that the values of discretion and honesty and protection and loyalty can guide rules for these information relationships. And the reason why we think that this is a good approach, a necessary approach to implement in data privacy laws, because privacy is more than just about personal information and secrets and control over information. Privacy at base is about power. The reason that companies want this information is because it is powerful. The ability to control what we see and what we click on is a power, right? And that is used in ways sometimes that is adverse to our interests. And it turns out that there are a series of rules that exist precisely to remedy those power imbalances, to make sure that those people that have power within relationships do not abuse it. And that is where we get to our proposed duty of loyalty and privacy law. So in this paper, which is the first of several papers, the next paper is going to add a little more specifics to the duty. We first say, well, what should a duty of loyalty seek to accomplish in information relationships? So the first question that Neil and I came to was, well, it turns out that a duty of loyalty is very common in another area of the law known as fiduciary law. And fiduciaries typically are bound by duties of care, duties of loyalty, and duties of confidentiality, or sometimes just duties of care and duties of loyalty. And we went and studied a lot of those relationships. And within those kinds of protective relationships, and many of you are familiar with what these are the relationships between guardians and wards, between trustees and beneficiaries, between professionals and their patients or their clients. We said, what does a duty of loyalty require in those relationships? And it turns out that there are sort of two different varieties of a duty of loyalty, or two different missions. The first kind of mission is strict obedience, right? So in certain circumstances, a party that is bound by a duty of loyalty is bound by a duty of obedience. You have to do exactly what the trusting party says. Now, there are a lot of advantages to this. One, it sort of complies with these notions of data privacy as one of being about informational self-determination. But ultimately, Neil and I argued that the appropriate way to define a duty of loyalty for data privacy law is to require parties to be that are bound by loyalty to follow the best interest of the trusting parties. Sometimes this will mean obedience, right? So when it's clear that the decision is knowing, that it's voluntary, that the proper incentives exist for individuals to make contemplative decisions, then obedience will be the rule, but not in every instance. And so this actually requires a broader, we think much more holistic approach to a company's calculus when making decisions about collecting data and designing their systems that requires companies to look out for the best interests of individuals. Now, we do importantly limit this and say that companies should be looking out for the best interest of trusting parties to the extent of their exposure. So one of the things that sort of came up when we presented this paper elsewhere is, how far does this best interest obligation go? And of course, we're not suggesting that companies like Google and Amazon need to be making decisions to make sure that their users brush their teeth at night. But to the extent that people expose their data, to the extent that people make themselves makes themselves vulnerable to mediated environments that can alter their choices, then we do think that there is a reasonable framework that can be applied that requires them to act in the best interest of users in those situations. So how would a duty of loyalty manifest within statutory regimes? And we envision at least 3 different ways in which a duty could be basically effectuated within the law. The first are rules to compel or constrain behavior. And the first of those, we would say, would be an outright duty for no conflicted design or data processing. So the very essence of a duty of loyalty within fiduciary law is simply to avoid actions that conflict with a person's best interest. And so we conceive of a rule that would follow along those lines, that would essentially be a no conflict rule. And so instead of an outright affirmative obligation to always be acting in the best interest of users, instead we suggest that the obligation be framed in negative terms, that companies be prohibited from either collecting or processing data or designing information technologies in ways that conflict with the best interests of trusting parties to the extent of their exposure, which of course would allow all sorts of behaviors that are in harmony with a user's best interest, or at least do not conflict, right? So if it's ambiguous, then companies can do it. And so we think that phrasing it in terms of no conflict rules allows for the necessary flexibility for companies to engage in what we think would be permissible and non-harmful activities. The next thing that we envision is invalidation of attempted waivers. So companies bound by a duty of loyalty would not then be able to disclaim that obligation or relieve themselves of a trustworthy design or trustworthy data collection and processing, because to do so would be disloyal. And the nature of the information relationship is such that that any sorts of waivers we think would be largely invalid. And then the final one would be disclosure requirements, mandated disclosures. The duty of loyalty could compel what we have argued elsewhere would be the duty of honesty. And there's transparency, and then there's forthrightness, in the words of Paul Ohm in a really great article he wrote called Forthright Code. Transparency is taking sort of everything that you're obligated to disclose and dumping it into terms of use agreements. Whereas honesty would be about, and forthrightness would be about disclosing the things that you would rather not have revealed in a way that you feel very confident would be internalized by the trusting party. And if you can't do it in that way, then you should not be allowed to engage in certain kinds of disloyal activities. We also in the article address the question of when should companies be bound by a duty of loyalty. We argue that there are 4 conditions that when present should give rise to a duty of loyalty. The first is when trust is invited, and we think that this is actually endemic among the digital environments. And so companies are always inviting certain kinds of exposure. If trust is the willingness to make yourself vulnerable to the actions of another, then this is routine in online spaces. So when all 4 are met, so 1, when trust is invited; 2, by one with a large power and information disparity over another. One of the, I think, erroneous frames that we have in the law generally is the idea that people that use information systems and companies that design and offer information systems stand at arm's length to each other as though there weren't a massive information and power disparity. But because these companies have so much information on us and are able to control our experiences, we think that often they have large power over us, and that further deepens our vulnerability. And so that's the second and third requirements. And then fourth, that the weaker party exposes themselves, relying that their trust will be kept. And we don't mean sort of a willing exposure thinking that nothing will go wrong, right? But rather we mean that willingly exposes themselves with the idea that my well-being is now in your hands, right? And people do that, we think, on a pretty regular basis in online spaces. And so there are also possible loyalty frameworks. So the most obvious one that is the cornerstone of our proposal is a relational duty, right? A duty to that companies refrain from data processing and design that conflicts with the user's best interests. But it doesn't have to be just a relational duty that binds perhaps the most powerful companies. You could also think about rules that encourage loyal-like behaviors. So some of the proposals that have been introduced to the federal level, we think are actually aimed at least indirectly encouraging loyal behavior. For example, prohibitions against dark patterns. That is the kind of rule that encourages companies to keep from deploying people's own limitations against them, right? So the CFPB, for example, has a rule against abusive trade practices that prohibits companies from leveraging people's own limited resources and limited understanding against them. We think that that's the kind of rules that encourage loyal behavior. We also think that if companies were bound by duties of loyalty, it would enable some really interesting remedies. It would enable perhaps some restitutionary remedies, because gains would be wrongfully gotten in violation of or through disloyal behavior. And it would allow companies to focus less on the harm requirements, because under fiduciary law, the harm comes from the corrosion of the integrity of the relationship, rather than requiring some sort of showing that you suffered extreme emotional anguish and the like. And so I want to make sure that I'm doing okay on time. So what would be the benefits of a duty of loyalty? We think that there are several, one of which is that a duty of loyalty is sensitive to power disparities in ways that data protection law simply is not. So data protection law is, of course, cognizant of power disparities, but it regulates them in almost an indirect kind of way. A lot of the data protection rules that we've seen in the United States regulate small companies and large companies the same way, because of course the focus is on the data itself, right? It doesn't matter whether your data is held by a small business or by Amazon. A duty to delete means they all have to delete the data, right? But one of the advantages we think, because we think privacy is about power and about how that power is collected, how it is distributed, and how it is used, is that a duty of loyalty is completely contextually tethered to that. So the larger the power disparity, the less conduct large companies will be able to engage in that would be potentially adverse to someone's best interest because of the extent of the vulnerabilities, right? In other words, the more protective companies have to be, the more vulnerable we are. And that's baked into the substance of duties of loyalty. Two, we think that a duty of loyalty targets financial incentives for exploitation. So a lot of what Neil and I have observed over the past 10 to 20 years of privacy law regulation is that companies are sort of willing to embrace this control and notice and choice approach to privacy because it allows companies to keep doing what they want to do financially to gain a leg up while passing a lot of the risk onto the user, right? So when control is given to you and you make the choice, right, then all of a sudden that risk is placed upon you. And we think that a duty of loyalty would correct those financial incentives in really important ways by centering the trusting party's well-being at the absolute core of data privacy laws in the United States. One of the advantages of building upon a duty of loyalty is, although it's new for data privacy law and for information relationships, the concept of loyalty is in fact not new. It's quite old. And it would build upon and draw from long established rules. And our next paper actually is going to be looking at a lot of these long established rules and finding analogs for information relationships. One of the reasons we think a duty of loyalty would be valuable in privacy law is because it is compatible with other data privacy frameworks. So last year, Neil and I wrote an article where we said a good approach to data privacy doesn't involve just regulations on data, though that's part of it. But it actually, we contemplated a layered approach where there were structural revisions within companies, there were rules about data, there were rules about externalities, so not imposing externalities to people's attention spans, to the environment. And then finally, rules within relationships. And we view these as in harmony or being able to coexist with the CCPA or a lot of the laws that are being proposed at the federal level. And so we think that this is really important as we sort of weigh whether we need an omnibus privacy rule and whether an omnibus privacy rule at the federal level can coexist with rules at the state level. And because of that harmony, because of the relational duties as opposed to the data duties, we think that this is an interesting point of intervention that can only further protect privacy in the United States. And one of the reasons we like this is because it does focus on more than just personal data. It also focuses on the design of information technologies. So a lot of what Neil and I have noticed over the past couple of years is that a lot of the harms are not direct harms relating to data. In other words, it doesn't involve someone directly breaching confidentiality or using one particular data point to make a harmful decision, but rather there are these architectures of vulnerability, to quote Dan Solov in his important work in the early 2000s. These whole systems are basically designed to further make us vulnerable, right? So we're vulnerable at the first instance when we expose ourselves, and the longer we continue to use these systems, the more vulnerable we get. And when you only focus on personal data, you tend to miss what's happening in the background with all of these systems that are encouraging us to expose ourselves more and more in ways that are almost imperceptible at the legal violation stage. And finally, one of the reasons we think that there's great value in a duty of loyalty is that it is less likely to clash with free expression goals and rules, which is, of course, a dispute that's been ongoing in multiple different areas. But because this is limited to voluntary relationships, we think that there are fewer potential pitfalls with a duty of loyalty because companies choose to invite the vulnerability and people choose to engage in relationships. Now, that leads to some potential objections about a duty of loyalty, and maybe we can get into this with the Q&A period. Some say that they are in spirit in favor of, or in theory in favor of a duty of loyalty, but it worries them because it's too vague. What does it mean to not to be prohibited from actions that conflict with a trusting party's self-interest, which is a fair, it's a fair concern, but if you look at the pattern of the ways in which duty of loyalty is developed generally, they almost always start out vague. I mean, negligence started off as be reasonable to, don't create an unreasonable risk of harm to others. And then over time, it gets filled in. And in fact, in statutory regimes, there's actually a two-tiered approach where they start off with the general duty and then they have subsidiary duties. And what Neil and I are arguing for in our next work is the creation of a number of different subsidiary duties around concepts of moderation, around concepts of manipulation, around concepts of personalization, and around concepts of commodification. And so we think that some subsidiary rules would help clarify that. One of the objections that's been brought up is the idea of conflicting loyalties. What happens when the best interest of party A conflicts with party B and the company has to follow both of them? We think there are answers to that as well, because of course fiduciary law also deals with this. It's done through abstractions. It is done through prioritization. One of the certain limits of fiduciary law generally, and a duty of loyalty specifically, is that of course it only applies within information relationships. So it doesn't limit the data broker that has no relationship to the person who they have data about. And we think that that sort of limitation is actually important in order to get the robust version of a duty of loyalty, and really to be able to fully bind those. And there are other rules, like we said, the duty of loyalty will not solve all problems in data privacy law. It has to be part of a layered approach. But we think that that's actually a virtue of the duty of loyalty, not just a limit. And then of course there are questions about, would this risk entrenching the status quo, because large companies are quite adept at being regulated, whereas smaller companies might struggle. And because of the high cost of a duty of loyalty, could it end whole practices? In terms of the status quo objection, we just note that this is potentially an objection for lots of different regulatory interventions. And then and one that's the larger point is, if a company cannot engage in a practice in a safe and sustainable way, right? So if the practice that the company wants to engage in is at base disloyal, I think it's worth asking whether we want to allow it in the first place, and that there are certain practices that probably are due to end because they are disloyal, and that's actually part of our normative prescription. So that's the paper. We think in the end that loyalty could be a revolution in privacy law and is a important component of a holistic approach to privacy law in the United States and around the world. We'll note that duties of loyalty have been proposed elsewhere, including the Data Governance Act as proposed by the European Commission. So this is not just something that's limited to the United States, but is being considered worldwide. Thank you very much. I appreciate it, and I'm happy to now take any questions.
All right, what do you think? Thanks so much for the presentation. Let's use the Zoom Q&A tool for questions. So please post your questions in there. And while folks line up with their questions, I'm going to go ahead and kick us off. Following up on Woody's point about how this work might integrate into the slate of proposals at the federal level, at the state level, internationally, that might make progress on consumer data protection. So one of the concepts that's attracting increasing attention is a shift from an opt-out model to an opt-in model. And Woody, I'd like to ask you about that, since part of the setup for the paper is this rejection of choice as a way to address the privacy issues that motivate you. And so my question has two parts. First, do you view the opt-in approaches that are gaining steam as a sufficient response, or a partially sufficient response, to the failure modes you touched on for choice, such as there are too many choices are too difficult to understand and use, they're too prone to manipulation, or do you see opt-in as fatally flawed in the same ways? And the second part of my question is it reasonable to think about opt-in choice as consistent with an obedience version of the duty of loyalty? That is, are these things in some sense synonymous? So I'd love your take on those two issues.
That's such a great question. So my initial reaction when I hear the question is that opt-in is just a sort of slightly more palatable version of opt-out, both of which are representative of the notice and choice framework. And so therefore should be, not our primary, like there's a lot of debate over this right now, but both of them, I think, we're arguing over whether red deliciouses are, it's a red delicious apple or a Gale apple, but it's still an apple, right? And what we need is a cornucopia, right? But you're right that that in a way opt-in is a little bit like the obedience model, right? Or at least it's some version of the obedience model. But the problem that I still see with the opt-in model is that it's not as though it's real obedience in the same way that it's not real control, right? Because it is a slate of options that are still being presented to someone, right? That still says, you can do X, Y, Z. Part of Neil and I's idea is that a duty of loyalty would allow us to move past consent as a regulatory mechanism entirely, because I will say that Neil and I view consent as a broken regulatory mechanism for privacy law, just full stop. And what a duty of loyalty could do is actually disassociate the concept of consent from the concept of choice, right? Because right now those two things are sort of tethered closely together. And the ideal, as Neil and I see it, is to have a system where people are protected no matter what they choose. Whereas under consent models, they're actually not protected, right, if they make the wrong choice about consent. And so I could see an opt-in model in harmony with a duty of loyalty, because the duty of loyalty would constrain the choices that were presented to people in the first place. But I don't view them, I guess, as synonymous, right, for those reasons.
That's very helpful. Thanks. Okay, our next question is from Mihir, who directs our tech policy clinic. Mihir, hopefully you're able to turn things on.
Yeah. I don't know if I think the video doesn't turn on, but Woody, thanks for this. One thing that Jonathan, Arunesh and I wrote a paper about dark patterns, and one of the things we were struggling with there was, how do you define what's in the best interests of a consumer? What metrics would you use? And then I've litigated cases involving fiduciary breaches of duty, say to shareholders, and what the content of what is in the best interest is often kind of where the rubber meets the road. And so if you can talk more about how would you go about defining best interest?
Yeah, so this is a great question, and it's a really good one, and it gets to the heart of our proposal. So this is something that Neil and I are continuing to work on. So it's difficult to say that there's one sort of definition that we would use, other than to say we would limit the definition of having to watch out for their best interests to the extent of their exposure. That's the way in which we articulated it. And what we mean by that is you can measurably look at the ways that people are exposed in their information relationship with a company by the data that they either voluntarily give or shed as part of their interaction with the system, and their ability to make choices within a mediated environment. And those are the two sort of constraining factors, so that this is not Google has to make sure that you eat vegetables. And then there are several ways in which you could imagine highlighting values. I mean, one of the values actually does go to meaningful agency within a mediated system. And so we look to the CFPB's definition that I referenced earlier, the deployment of people's limited resources against them. That's a infringement upon someone's agency or autonomy, which would be then against their best interest because it limits their ability to meaningfully interact. But it's not just that. One of the things that my team at Northeastern, I work with a team of computer scientists at the Corey College at Northeastern, is we're getting into this very difficult question, which is a related question, which is what makes a dark pattern dark, right? And a lot of it, because dark patterns are often conceptualized as patterns that work against the interest of the user, right? And for the benefits of the company, is the idea of not just the ability to infringe in choice or the increase in risk, right? Because there are also ways, I mean, so much about data privacy law generally is about increasing risk. But also, you could imagine things like the extraction of finite resources like labor or attention spans, right? So to the extent that someone consistently undermines your ability to focus or demands from you certain sorts of labor, we think that that probably would also act within their best, against their best interests. Or if it discriminates them in a way that leaves them worse off, right? So decision-making systems is something else that we're contemplating. If it discriminates them adversely, then that would be, so you could draw upon the sort of body of disparate impact law to conceptualize best interests. And so we think that there's a lot of different ways to bring these decisions to bear. One of the things that we're getting into is also, and this admittedly opens up a whole different box of things, is content moderation generally. The idea that when you fail to moderate, and you know that doing so is violative of the best interest of a certain number of people on the party, then that could also be a violation of best interest. So it actually is a combination of lots of different factors that what we're proposing be handled through the creation of subsidiary duties, which is what we're working on with our next project. So I suppose that's a long-winded way of saying that it's a work in progress.
Thanks, Woody. All right. Next up, Amy. Hold on just a moment. Do this. All right.
Okay, I think you can hear me now. Thanks. This is super interesting. I guess I have a question that is related to the too vague criticism that you mentioned earlier. I assume, and it sounds like this is happening with content moderation, I assume that you and your colleagues have thought through at least some concrete and complicated scenarios where these concepts of loyalty might come into play and how they might be operationalized. So thinking of an example that's like relevant to my prior work, how might you bring loyalty into play in a scenario like personalized ads, where having a personalized ad may mean that the ad is more relevant to the consumer, and that might be good. And it also could mean that it makes the consumer more likely to engage in impulse buying or overconsumption, which is bad. So I don't know if you have a scenario like that or other scenarios where you thought through the operationalization of some of these ideas.
Yes, that is, thank you, Amy, so much. It's funny you mentioned that. The final paragraph right before our conclusion in this paper actually talks about personalized ads. It's like a subtitle. It's like the end of personalized ads with like a question mark. And we put a question mark there because we don't necessarily think that micro-targeting is as a concept disloyal, but we think that the way that it is implemented, in fact, probably could be disloyal. Particularly, and you mentioned a lot of good points about things like impulse buying, but also extraction of unnecessary data for potentially minimal gains. And what we view as the benefit of the duty of loyalty is the idea that it places the burden on the trusted party to engage in the calculus as to whether this is best overall to the extent of their exposure, whether this is in the best interest, that relevance is not the only category to be considered here, that the consent is not the only sort of justifying mechanism, because this is not a pure obedience framework, but rather it's sort of like forcing privacy impact assessments on every single decision, and the guiding light of those impact assessments is best interests holistically, to the extent of their exposure, right? To the extent of the collection of information and the interaction within a mediated environment. But our conclusion, and it's a tentative one, and so again, it's hard to say with amount of certainty, but our conclusion is that we think personal ads might be able to exist, but not in their current form, right? So that ad targeting generally and third party and that personalization generally probably is articulately not in the best interest of a lot of users. But a lot of that involves some weighing about things like relevance versus overall submission to overall exposure and risk levels in ways that we haven't yet fully filled out. But if it makes you feel better, that's probably one of the very first contexts within which we will apply the duty of loyalty in our next article. We left off on this
one. Thanks again for the answer, Woody. And I'm glad you went into such detail on targeted advertising. Elizabeth had a very similar question about how your concept would apply in that marketplace. Next up, our fearless leader, Matt. And while Matt's getting ready, I would just note it sounds a little dangerously like you're substituting user best interests for like the GDPR legitimate interests analysis. It seems like there's a real parallel there, and many of the ways in which that analysis is broken down might apply to your analysis, but I don't want to derail things. So over to Matt.
Hi, thank you so much. I think my question kind of builds on the two previous questions, and that it's focused on best interest and what it means and how you operationalize it. I think one of the things your talk showed really convincingly was that how some concepts that make sense at one scale break down at another scale. So I like the example you showed where you can adjust some of your privacy settings. That makes sense, but then if you have to do that for thousands of systems, it doesn't make sense anymore. And so I wonder if best interest is a similar idea. That is, I think it evolved in a setting where the two people in the relationship actually knew each other, and it's possible for the more powerful party to know the best interest. So my doctor can know my best interest, or she at least has a decent chance of that. But in these more arm's length relationships or different relationships between companies and people, it's not clear to me that how any of these companies can actually know what our best interests are. So I guess my question is, do you really think best interest can work at scale?
That's a great question. Thank you. And it's something that Neil and I kicked around, and we got some really good feedback from people that work at large companies that say, this is not, depending on how you implement it, you could create lots of problems, because you're right. I mean, are you telling me that as a big company, we have to say what is in Woodrow Hartzog's best interest? And now, what is in Jonathan's best interest? And what is in Patrick's best interest? And Amy's, right? And the answer to that, which we hope to build out a little more in our next article, is that what's likely going to happen, and what happens, because of course, it's not new to fiduciary law that there would be large groups of trusting parties all at once, is the big one is it probably would be abstracted into a reasonable trusting party construct, right? So unless you have reason to know very specific things, then you probably act on a default presumption of a reasonable trusting party construct. Like, what is, in other words, the extent to which all of the people have a common set of risk, a common level of exposure, a common set of desires to meaningfully use their agency within mediated systems and avoid getting injured in very similar sorts of ways, right? And through that sort of abstraction, you can then create something that is more followable as a rule, rather than specifically saying, hey, you specific one person, this is your interest, which is actually different than someone else's interest. Neil and I still need to build out exactly how that interplays when companies actually do have reason to know what that someone's best interest would diverge from the reasonable person, the reasonable trusting party construct. But we have to do a little more work on that. But I think that's probably the way in which we would want to deal with it, because you're right. When you have billions of users, it can't be rational to say that everyone gets to choose what their own best interests are, right? Or that you're held accountable to a billion different unique particular best interests.
Thank you.
All right, since we've come up on the 1:30 mark, I think we should wrap up here. There are some outstanding questions, and so at the risk of extracting a commitment on the spot, call it a dark pattern, if you will. Woody, would you be okay if folks emailed you with their follow-on questions, and Neil too? I'm taking the nod as an expression of opt-in consent.
Yes, that is a voluntary and knowing. Please do email Neil and I. Neil, I think actually, if he's not on now, has been listening in. Oh wait, no, he had a comment. I just scrolled down. Please email us both, and we look forward to hearing from you. Thank you for such excellent questions. I'm sorry we didn't get to answer them all.
All right, well, thank you again for joining us. Stay tuned. We'll have many more excellent CITP seminars throughout the remainder of the academic year. All right. Take care, everyone.